Welcome to this webinar presented by the It's My Choice project from the Barbara Schleifer Commemorative Clinic. The It's My Choice project is funded by the Department of Justice Canada. This webinar is one in a series that gives basic information about areas of law that may be helpful for survivors of gender-based violence. This webinar will focus on removals from Canada. The information in this webinar is current as of February 19th, 2026. Please note that the webinar is designed to provide legal information and does not give legal advice about any specific situations. If you or someone you know has specific legal questions, it is best to consult with a lawyer. If you need help finding a lawyer, you can contact your local legal aid clinic or the Barbara Schleifer Commemorative Clinic. Let's begin the webinar. A removal order is an official legal order requiring an individual to leave Canada. A removal order is issued when an individual is found inadmissible to Canada or if they have violated Canada's immigration laws. There are three types of removal orders, each with different consequences. In addition, each type of removal order has specific requirements that must be met if the individual seeks to re-enter Canada. The three types of removal orders are departure order, exclusion order, and deportation order. A departure order is the least severe type of removal order. It requires the individual to leave Canada within 30 days after the order becomes enforceable. It also requires that the individual confirm their departure with Canada Border Services Agency, or CBSA, and obtain a certificate of departure. Removal orders can become enforceable very quickly. In some cases, they become enforceable the day they are issued. If you have questions about a removal order, it is best to consult an immigration lawyer as soon as possible. If the individual subject to a departure order leaves within 30 days and confirms their departure with CBSA, there are generally no additional penalties. That individual may be able to return to Canada in the future, granted they meet entry requirements at that time. If the individual does not leave within 30 days or does not confirm their departure with CBSA, the departure order automatically becomes a deportation order, which carries very serious consequences. Deportation orders will be discussed in the next slides. An exclusion order means an individual must leave Canada immediately, confirm their departure with CBSA, and that individual cannot return to Canada for a specific period of time. In most cases, an exclusion order is issued for 1 year for less serious immigration violations, such as overstaying your authorized period of stay, or studying or working in Canada without legal authorization. In cases where the exclusion order has been issued for misrepresentation, the exclusion order is issued for 5 years. Essentially, an exclusion order creates a temporary ban on returning to Canada. The calculation of the exclusion period begins when the individual receives the certificate of departure from CBSA, confirming that they have left Canada. That individual may be able to return to Canada in the future after the exclusion period, which is either 1 year or 5 years, has passed, granted they meet entry requirements at that time. However, the presence of an exclusion order in an individual's immigration history may significantly impact future applications to Canada. If the individual wishes to return before the exclusion period has passed, they must apply for authorization to return to Canada. A deportation order is the most severe type of removal order. A deportation order means an individual must leave Canada immediately and confirm their departure with CBSA, similar to an exclusion order. Deportation orders are usually issued in cases where an individual has criminal inadmissibility, presents a security risk, or has committed human rights violations. They are also automatically issued when an individual subject to a departure order does not leave Canada within 30 days, does not confirm their departure with CBSA, or does not follow other administrative requirements. However, An individual subject to a deportation order is permanently banned from returning to Canada. Essentially, a deportation order creates a lifetime ban on coming back to Canada. If the individual wishes to return to Canada at any time in the future, they must apply for an Authorization to Return to Canada, or ARC. If they return to Canada prior to being issued an ARC, a subsequent deportation order may be issued. There are two bodies that issue removal orders. First, the Canada Border Services Agency, or CBSA, is the federal government's immigration enforcement agency, responsible for making removal arrangements, also for border protection and control, and for immigration detention. CBSA has the authority to issue removal orders to refugee claimants, specifically conditional departure orders when they make the refugee claim, and to also issue removal orders to foreign nationals. Under Canadian immigration law, CBSA is legally obligated to remove any foreign national with an enforceable removal order as quickly as possible. Generally, it has been CBSA's practice to prioritize removal of foreign nationals who are being removed due to national security concerns, serious criminal offenses or involvement in organized crime, and human rights violations. Second, the Immigration and Refugee Board, or the IRB, is an independent administrative tribunal that decides various immigration and refugee matters. The Immigration Division of the IRB has the power to issue a removal order against a foreign national or a permanent resident after an admissibility hearing. The Immigration Appeal Division of the IRB deals with removal order appeals for eligible individuals. Removal orders can be issued for a variety of reasons. For example, a removal order can be issued for overstaying your legal status or authorized period of stay in Canada. A removal order can be issued for working or studying in Canada without proper legal authorization, such as a work permit or a study permit. A removal order can be issued for having your conditional departure order become an enforceable departure order after a rejected refugee claim, appeal, or judicial review in some cases. A removal order can be issued for misrepresentation, such as committing immigration fraud, submitting false documents, lying to immigration authorities, or failing to disclose important information. A removal order can be issued for having criminal convictions, depending on the type of offense you were convicted of, where the offense occurred, the sentence issued by the criminal court, and whether your status in Canada is a foreign national or a permanent resident. A removal order can also be issued if you present a risk to the national security of Canada or if you have committed serious human rights violations. And finally, a removal order can be issued for being non-compliant with the conditions of your visa or your permit. There are other reasons why removal orders may be issued. If you need assistance to understand why you were issued a removal order or why you may receive one in the future, consult with an immigration lawyer. Some individuals require authorization to return to Canada after removal. Authorization to return to Canada, or an ARC, is a special permission from Immigration, Refugees and Citizenship Canada, or IRCC, to re-enter Canada after your removal order was enforced by CBSA and you were removed. For a removal order to be enforced, you must appear before a border services officer at the airport or land border to confirm your departure from Canada, obtain a certificate of departure and actually depart from Canada, and be authorized to legally enter your country of destination. If you receive an exclusion order, you need ARC if you want to return to Canada during the exclusion period. If you received a deportation order, you are permanently barred from returning to Canada. Therefore, you cannot return unless you apply for and are granted an ARC. There are other circumstances where you may need an ARC. For example, if you departed Canada but did not receive a certificate of departure from CBSA. If you have questions about whether you need an ARC, it is best to consult with an immigration lawyer. When assessing whether to grant an ARC, IRCC looks at various factors, including the reasons for your removal, the likelihood that you would repeat the same violations which led to your removal, the reasons you now wish to re-enter Canada, and other factors. If CBSA paid for your removal, you must also pay the ARC application processing fee in addition to your removal costs. If you have to repay your removal costs back to the Canadian government, IRCC will let you know the exact amount once they start processing your ARC application. In reality, it is very difficult to obtain a positive ARC, especially if the circumstances that led to your removal order being issued have not changed. There are some countries which the Government of Canada has temporarily paused deportations to because of very dangerous country conditions. The CBSA has put in place an administrative deferral of removal or a temporary suspension of removal for some countries. An administrative deferral of removal, or an ADR, is a temporary pause on removals to specific countries with humanitarian emergencies. A temporary suspension of removal, or a TSR, is a temporary pause on removals to specific countries where there are dangerous conditions for civilians, such as armed conflict or environmental disasters. The main difference between these two measures is that ADRs are typically put in place for short periods of time to respond to changing country conditions. It is important to note that individuals with serious inadmissibilities, such as national security or criminality, do not benefit from a stay of removal or a pause on their removal under ADR or TSR measures. The ADR or TSR measures can also be lifted at any time, typically when country conditions improve. And if they are lifted, CBSA will resume enforcing removals for all individuals from these countries who are subject to enforceable removal orders. You can find the list of countries currently subject to ADR or TSR measures on IRCC's website. You may also hear these countries referred to as moratorium countries. If you are from one of these countries and have a removal order, speak with an immigration lawyer about your options. Once a removal order is enforceable, CBSA can take steps called enforcement actions to ensure you leave Canada. These enforcement actions can include requiring an individual to report regularly to a CBSA office, detaining an individual deemed a flight risk or unlikely to appear for immigration proceedings, or individuals who are deemed a danger to the Canadian public, requiring individuals to apply for travel documents in order to re-enter their country of citizenship, and coordinating removal flights and travel arrangements. If an individual fails to appear for a CBSA appointment or for their scheduled removal date, CBSA can issue a Canada-wide immigration warrant for that individual's arrest. CBSA can also arrest an individual without a warrant if they have reasonable grounds to believe the person is unlikely to appear for future proceedings or removal, or for other grounds. It is very important to attend all CBSA appointments and interviews. If you receive a call-in notice from CBSA and need support to navigate next steps, consult an immigration lawyer as soon as possible. If an immigration warrant is issued against you, CBSA officers may visit your last known residential address. They will also try to contact you at your last known email address and phone number. You may be arrested by CBSA following an interaction with police services, for example, at a traffic stop or an arrest for a criminal offense. Once arrested by CBSA, an individual may be detained in immigration detention, possibly until their removal is carried out. If you have received a removal order or are concerned about potentially receiving one in the future, consult an immigration lawyer as soon as possible about your legal options. Some legal options include, but are not limited to, a removal order appeal to the Immigration Appeal Division, or IAD, of the Immigration and Refugee Board. Certain individuals have a right to challenge their removal order on legal grounds, or to have it stayed or set aside on humanitarian and compassionate grounds before the IAD. A pre-removal risk assessment, or PRA. A PRA is a process that assesses whether a person facing removal from Canada would face persecution, torture, or a risk to their life if returned to their country of nationality. A deferral of removal request to CBSA. A deferral request is an administrative request asking CBSA to temporarily postpone removal, usually due to short-term and/or humanitarian considerations. A stay motion before the federal court. A stay motion is an urgent application before a judge seeking to temporarily suspend removal from Canada for specific reasons. A humanitarian and compassionate, or H&C application. An H&C application is a way to request permanent residence in Canada based on compelling reasons if you do not qualify for any other standard immigration pathways. While submitting an H&C application will not delay your removal, submitting one may be part of your next steps depending on your personal unique circumstances. A temporary resident permit, or TRP. You may seek a normal TRP or one for victims of family violence, depending on your circumstances. A TRP for victims of family violence is a discretionary permit that allows individuals experiencing abuse from their spouse or common law partner to have temporary status. While a TRP for victims of family violence may not directly delay your removal, submitting one may be part of your next steps depending on your personal unique circumstances. Speaking to an immigration lawyer is crucial, as your legal options depend on the individual facts of your case. There may be other options available to you that have not been mentioned in this presentation. If you are a survivor of gender-based violence, you may access 2 hours of free legal advice on a certificate from Legal Aid Ontario or contact the Barbara Schleifer Commemorative Clinic. The Barbara Schleifer Commemorative Clinic offers legal, counseling, and interpretation services to marginalized and racialized populations of women and gender-diverse people who have survived violence. The It's My Choice project aims to increase access to justice by providing fully integrated, trauma-informed, independent legal advice and independent legal representation to women and gender-diverse people who have experienced sexual assault and/or intimate partner violence. For sexual assault survivors, this includes criminal and non-criminal options. For survivors of intimate partner violence, this includes family law, immigration law, and intersections with criminal law. Furthermore, in partnership with community organizations across the province, sexual assault and intimate partner violence survivors will have the option to access these services remotely or at satellite or pop-up clinics and on-site at the Schleifer Clinic. Thank you for watching this presentation from the It's My Choice project at the Barbara Schleifer Commemorative Clinic. Please note that the information in this webinar is current as of February 19, 2026. Immigration laws, policies, and requirements may have changed following the recording date of this webinar. If you have questions or would like to speak with a lawyer, you can contact the Barbara Schleifer Commemorative Clinic at our website or at 416-323-9149. Thank you.